Good afternoon, students. Today we're going to be discussing in this video lecture Chapter 7, Compulsory Self-Incrimination. And remember that subject, compulsory, being compelled by the government to incriminate yourself. And we're in the area of evidence, and this evidence involves the person. The person, compelling a person to furnish evidence. And that evidence is going to be of two types. Testimonial evidence, where you are furnishing information under the Fifth Amendment, information that would incriminate you under compulsion. And the second type of evidence is physical evidence, where you are seized in most cases in some way, either temporarily, or you're seized as part of an arrest, and you are at that point, the certain physical evidence is taken. Now, physical evidence in regard to a person on the body consists of two types. The first is what is called appearance evidence. That is evidence that is visible on your person. You have to put yourself in this. Put yourself in the, it's hard to do sometimes, but assume that you are, you're the subject, the suspect. And at this point, you have been seized, and the government, through its agents, is about to obtain evidence from you. Well, appearance evidence is the type of evidence that is readily apparent to that agent. Now, the other type of physical evidence, however, is bodily evidence. That is evidence that is on your person, but it is not readily visible. That evidence, again, begins with, in almost all cases, some type of seizure so that the evidence can be taken, and that seizure has to be constitutional. So the seizure, or constitutional seizure, in regard to bodily evidence, we're going to look at some additional requirements as opposed to appearance evidence, evidence that is there, visible to you. Let's look at, number one, testimonial evidence first. Again, compelling testimony from you. The Fifth Amendment privilege applies through the court decisions. The Fifth Amendment privilege not to be forced to furnish incriminating information is applied both inside and outside the courtroom. All legal proceedings, it basically, that Fifth Amendment applies 2 degrees of protection. There's 2 degrees of protection that you have about furnishing testimonial evidence. One, you have the absolute right not to speak. You have the right to be silent, and that absolute right is only in 2 situations. One is during a custodial interrogation, that's outside the courtroom, and the second is inside the courtroom, when you're being, the government compulsion for you to speak, you can claim that absolute right. Now, that absolute right can only be taken away if you waive it, or if the government grants you a form of immunity from prosecution for the information that you would be compelled to reveal. All other situations, as opposed to the right, to remain silent, you may be compelled to appear and to testify. So you have the right, but that right doesn't extend, except for the right to silence. You can appear and testify. Now, if you're asked to furnish incriminating information, then you can claim the right of silence in those situations, but you can't claim the general right of not speaking in other circumstances outside of the criminal trial and the custodial interrogation. So when we look at the Fifth Amendment right, to claim the Fifth Amendment right not to testify, we're going to need three basic criteria. One, it has to involve your testimony. That means you're giving information. And that information is information related to your guilt. It incriminates you in regard to a criminal matter. You have to be compelled. It means it's not voluntary. You've been compelled to do it by the government, or its agents, and then it has to be, again, self-incriminating. Those are the three criteria. The testimony itself can include any type of behavior. That it can include behavior that is not just verbal in some cases. It can be some type of explicit things that you might do. Testimony might, it could be information that basically is not always verbal, but most of the time it is verbal testimony. Okay. Self-incrimination, the self-incrimination issue. The certain types of information you can be compelled to give that seems to be testimonial, but the courts have, through the Supreme Court decisions, we know it is not. Booking questions, for example, where you're giving biographical and demographical information about yourself, that's been held not to involve actually a Fifth Amendment issue because it is not self-incriminating. The immunity issue. If you've been granted immunity from prosecution, you may not invoke your Fifth Amendment right in those circumstances. Now, only a prosecutor can grant immunity, and the immunity that they grant, the use immunity. There's two types, absolute and use, but generally what we're talking about today is use immunity, where they can't use your direct testimony that can be used against you in a criminal proceeding. That means that it doesn't mean that they can't, if they give you immunity, under use immunity, it doesn't mean that they can't charge you with the crime that you may have talked about. They just can't charge you on the basis of information that they gleaned from you by giving you the immunity. So remember that. You can be charged with the crime that you've been given immunity for use immunity. They just can't use your testimony in any way to have charged you or to bring or to actually introduce, if you've been charged successfully, to introduce at a trial. Go into appearance evidence. When we say appearance evidence, what are the common types? Well, again, visible. The idea of being able to compel you and your body itself is the evidence. Well, the first one is the most obvious, is the lineup. You know, if an arrest has taken place, the lineup can be used as long as and an attorney does not have to be present unless you have been formally charged, you know, where the Sixth Amendment right would attach. And that, again, takes place at the earliest time possible where a judge and a prosecutor are now involved, and that's normally the arraignment. It can also be an indictment. It can be a preliminary can be the preliminary hearing, but it's normally at the arraignment. It's not generally at the arrest stage, unless that arrest is part of an indictment. Some state laws may vary that, but that's our general rule. So generally, an arrest takes place. An arrest, you have time. You've got basically, you know, several hours before you have to take an individual before the magistrate. If you can put the lineup together, then that lineup can be you have to undergo, you can be compelled, as if the police want to force you into the lineup, you're compelled to do that, and you can be ID'd during that lineup. During a temporary detention of somebody, if you're temporarily detained, you may be compelled to have witnesses to look at you. You may be compelled to remain there while that's being done. The photographing, detained or arrested, and be photographed. You can be measured, you can be fingerprinted, handwriting exemplars can be taken. You can also take voice exemplars. Field sobriety tests can be given. Again, these can all be given within the time limits that are allowed by the type of seizure that's involved. Temporary detention, relatively minimal amount of time, although many of these things can be, the lineup is the one that could not really feasibly be done during a temporary detention. During an arrest, all these can be done relatively easily during the requisite time that you have. How are these attacked? Normally, this type of evidence by the seizure. If the seizure can be found to be unconstitutional, no reasonable suspicion for a temporary detention and no probable cause for the arrest, then the evidence itself, which will be causally connected, can be suppressed. The other way that can be attacked is the procedures that were used that can be a violation of due process. The way it was done, even though there was probable cause for an arrest or there was reasonable suspicion for a detention, how you conducted the how you basically took or utilized that appearance evidence can be done in a manner that violates due process. That's another way you can lose that evidence. Some jurisdictions have procedures in place where the court can actually issue an order compelling someone to appear before the police and furnish this evidence. In those circumstances, they do not need the probable cause or the reasonable suspicion at the time. Although they're going to have to satisfy the judge that they normally have reasonable suspicion to get that type of order issued. But it certainly it eliminates some issues if you have time to do it. That's often a good way to do it. Especially when you don't have the probable cause for an arrest, you can still get all these procedures done with the order. Okay, when we look at the appearance, we've got the two types of physical evidence, the appearance evidence. We also have to look at bodily evidence. Now that entails, again, beneath the surface. And we're looking at the Fourth Amendment search, really the most serious types of bodily evidence, the ones that have the most protections. Why is it so different? It's the privacy interest predominantly. And the privacy interest under the Fourth Amendment means that you're going to have probable cause, which means it's going to normally be a search warrant or an arrest warrant in some circumstances before you can take any type of bodily evidence or do a more intricate bodily search or a strip search. Strip search can be conducted with just the arrest warrant. When you start talking about cavity searches, you're going to need really a much more restrictive procedure because of the enhanced privacy considerations and due process considerations in regard to risk to the individual themselves. Medical personnel have to be present. Strip searches, you're going to need a reasonable suspicion standard. It's reasonable suspicion that the evidence you're looking for actually entails that it's hidden, that there's a reasonable belief that it will be there and revealed if you utilize a strip search. So it means you had to have grounds for the seizure, which again, for a strip search, you're going to need an arrest. So you have grounds for the arrest. Strip search means you have reasonable belief, reasonable suspicion that there's that type of evidence is being secreted on a person before you strip them. It has to be done. If you're going to do that, it has to be done basically under due process. If it has to be sexually neutral, I mean sexually separated. If it's a female officer is going to have to do the search. You can't have male officers observing it. It's the same thing with basically a male. Female officers really shouldn't be observing this procedure. So you do have the privacy concerns that are here, and they can be a due process challenge, how it was done. The surgical intrusions to recover evidence within the body. Normally we have the cases involving blood, drawing blood to determine DUI in situations. Well, in those particular cases, the default rule currently under the Supreme Court is that you should have a search warrant, but exigent circumstances can relieve you of the requirement for the search warrant, but you are going to need, under due process, you're certainly going to have medical personnel present and to actually conduct that type of procedure to draw the blood. Unless confronted with an emergency, exigent circumstances, you should, search warrants generally before arranging for procedure involve saliva, urine, semen, pubic hair, other bodily fluids, penetrating the body surface, examination of rectal or genital cavities, medical risk, or significant pain, discomfort, or humiliation. So you're looking at, once you get into these areas, now an exception to this, some exception to this is the arrest warrant itself is going to give you the authority to take swabs. It's going to give you the evidence underneath the fingers, evidence that could disappear relatively quickly. That's why you hand swabs for firearms residue, or can be done without a search warrant. That is appearance evidence, and its evidence can be readily dissipated. So that can be done without the search warrant. Once we get into the other areas, though, we're looking at it's a greater intrusion. You're going to need a search warrant, which is basically going to be involving as to why you need to take that particular type of evidence, that intrusion into the body, into the oral cavity, into the rectal cavities. And in some cases we have medical requirements for due process. But we do have the exigent circumstances requirement, except for the area of due process. There are no exigent circumstances when due process is going to be violated, where these circumstances where it shocks the court, shocks the conscience of the court, and that involves where you don't use the proper medical procedures or put people at great risk. Classic example would be, the pumping someone's stomach, where it was done in a manner where it could have been done in a lesser manner, where you could have just waited maybe for the evidence to pass. There's a lot of these factors in general are a little bit tougher. The strip searches, again, you're going to need the reasonable suspicion standard, but you need more for any type of body cavity search. Let me ask you a couple questions here, and we'll just see how well you handle this. And if we're looking at appearance evidence, and I gave you some examples, fingerprints, a lineup, voice recognition, where you're forced, compelled to speak certain words, not words that are incriminating, but speak certain words, hair samples, those items I've mentioned, can you be compelled to furnish all of those items without a search warrant based solely upon the arrest or seizure, temporary seizure that has taken place? Well, all of those do not require a search warrant. They can all be done through, the government can compel you to furnish that information. They're not testimonial in nature. and they did not involve any type of bodily intrusion or a privacy violation, an area of bodily evidence that was readily observable. Every one had something to do that it was readily observable and was not testimonial in nature. That's what you have to look for in exam questions. Be sure you analyze these closely. Look at the idea as to whether or not, once you move into any type of privacy violation, you know that you're in an area in which there are enhanced protections, and you're going to need more than just your arrest warrant. There has to be some additional information. The strip search is probably the easiest, and again, an arrest warrant is sufficient, but you also need a reasonable belief that the evidence that you're searching for requires that there's evidence on the person that requires a reasonable belief that evidence is being hidden and that it is there on the person. You just can't do it as a strip search for someone, for example, that was arrested for a white-collar crime that had nothing to do with physical evidence except for some records somewhere. It cannot be strip searched as part of the arrest procedure without facing a due process violation, which could cause you by doing that to actually lose other evidence that you may have gained by that search procedure, by the unconstitutional nature. But you just can't strip search everybody that's arrested. There has to be some reasonable belief as to why that strip search, what that strip search will turn up, and that it is important to the case that's being investigated. Any type of bodily intrusion or rectal type of search, again, we're looking at medical personnel and a much higher standard, of general necessity for that type of procedure. I think that basically should wrap it up. I hope this helps. And it's a tough area, but I'm sure that you should be okay. Just make sure that when you're looking at both the Sixth Amendment, the Sixth Amendment right to counsel issue, only springs up after someone has been actually formally charged. Then we're looking at something that has nothing to do with appearance evidence or Miranda rights. All we're looking at is the elicitation of incriminating information when the right to counsel is attached, and that's being done where the person has not been advised of their rights. It doesn't matter. It doesn't matter if they're in custody. If you try to elicit information from someone whose Sixth Amendment rights have sprung into being and they have not waived their rights, then that information is going to be suppressed. That's it for this afternoon, and I'll probably see you on this video, another video next week, and that will be the last one. Thank you.